I am 23 years old. I currently reside in Thornton, Colorado. I was also a part of the effort to pass the House bill back in 2013, and I'm opposing Senate Bill 69 today. My first job was working for a local sandwich shop. I was 17 and just started my senior year in high school. I was very excited to enter the workforce and to gain my independence. Unfortunately, within months of my employment there, I began experiencing sexual harassment from my general manager. The harassment ranged from inappropriate phone calls after work, late hours of the night, aggressive sexual remarks and made to me during work hours, and degrading me and other coworkers even in front of customers, and also persistent bullying. When I had asked him to stop, he blew it off as if I was making a big deal out of nothing. I felt extremely uncomfortable and unsafe during each shift that I worked with him. The owner was notified of the general manager's behavior several months into the harassment. Both myself and other coworkers made numerous complaints. Excuse me. Although the owner knew at least some of what was going on, he did nothing to protect his employees. The owner claimed that he had talked to the manager about his behavior, but his harassment of me and other staff never stopped. As I had mentioned before, that was my first job. I was never given a sexual harassment policy, but I also never knew to ask for one. At 17, you don't know every right you have as a worker. I didn't know what was happening to me was a violation of my basic civil rights. I was being preyed upon someone of authority and was older than me and a bully, and no one in the company was protecting me. At the breaking point, my general manager made an extremely inappropriate comment in front of customers, and I called the police because I no longer felt safe in my workplace. He was issued a ticket for disorderly conduct, and I was told to never return to my workplace. The owner gave me an option of either transferring to a different store that was managed by the general manager's brother or collecting my final check. I was too afraid to work for the brother of the person that had caused this situation in the first place, so I had no choice but to leave my job. This was my only other option. The manager who harassed me and others were given 1 week of unpaid vacation and then told not to come back to work, he was given 1 week of unpaid vacation and then allowed to come back on the job. I was the one who had lost my job. My mom and I worked together to bring a complaint against my former employer for sexual harassment in the workplace. It took me a long time to find an attorney willing to take my case because under state law, a person with a case such as mine is not eligible to be awarded attorney fees. Fortunately, we found a firm that was willing to work with my case for a fraction of the costs. We tried mediation to settle the dispute, but the owner of the store was only willing to give me 2 weeks of pay. Under the current state law, the only compensation I was entitled to, which was back pay, which amounted in $3,000 in my case. I did suffer a lot of financial hardships as a result of this case and losing my job. The law did not allow me to have my attorney fees reimbursed because I worked for a franchise that had less than 15 employees. To me, this is unfair. Fighting to protect your rights under the law is expensive, and no one should have to choose between putting up with sexual harassment at work and justice just because they work for a smaller sized business. All workers should enjoy the same protections no matter where they are employed. Because of our efforts over many years to pass 1136, our state law now protects me and other women like me. Now is not the time to be taking our state backwards by repealing a law that helps solve issues like the ones I faced.
Ms. Martinez, thank you so much for your testimony.
One more thing. With HB 1136, all the advocacy groups got duped because under HB 1136, size still matters. What Mr. Oddly was trying to say is that under HB 1136, a plaintiff has the same remedies available in Boulder, in Denver, and Adams County, where they have friendly juries, than they would under federal law. It's the same. Now they get the exact same remedies, but because of the caps, which are capped at $10,000 if you got under 5, and then $25K if you're 5 to 14, those are so small. What plaintiff's lawyer is going to take on a case against a small employer when they know now they're going to work hundreds of hours to try to prove discrimination, and they're not going to recover any more than 10K or 20K. HB 1136, as it stands now, provides Esmeralda and Rachel the same lack of remedy that they had before, because one thing I know about trial lawyers, they're going to go after the big fish where they can get the biggest recovery. And so what we've done is we've screwed employers while we have essentially created a self-defeating scheme that doesn't help the people this was intended to help. My last comment is this. There seems to be a tremendous amount of confusion about an unfounded claim and a frivolous claim. An unfounded claim is one that is unfounded. In fact, that's what CCRD finds in 95% of the cases, where employers are still spending thousands of dollars to prove they did nothing wrong in the first place. The EEOC issues no reasonable cause determinations in 2/3 of the charges that are filed. Because they're unfounded, because some of them are silly, that does not mean they are legally frivolous. I consider myself an old rattlesnake in this town. I've been practicing on the plaintiff side, I've been practicing on the defense side. I have never, no matter how ridiculous the case, seen a judge tell a plaintiff that their case was legally frivolous. It never happens. So to say to someone like me, well, they're going to be deterred by frivolous cases because they know that they may bear the risk of paying the attorney's fees is completely illusory, because it doesn't happen. I want us as a state to be innovative. I want us to care about discrimination. I want us to care about advancement. I am the proponent of the webinar I've written a lot called 8 Sparks to Jumpstart the Stalled March Toward Equal Employment Opportunity. There is a lot we could be doing to cure discrimination, since I know that that was something that you unfortunately experienced. There are a lot of things we can be doing short of litigation that partner with employers, doesn't burden them, and makes it easier to sue, and to make them easier to sue. In fact, there is a compelling business case for multicultural workplaces and multicultural and inclusive decision-making that is far more powerful. As I've always said, even though I'm a social worker, if you want to change how business thinks about business, you have to make the business case. And it's here, because litigation is for losers.